Good evening, everybody. I'm Peter Kiely, one of the partners here at the firm, and welcome to the live stream from the studio. I was just saying to the speakers, so we've got people here in our boardroom and about 100 plus of you online, and a good number from Australia and overseas, which is great. There was huge interest in the changes to the Privacy Act and what it might mean. So we have tried tonight to make a very practical seminar from 5:30 to 6:30, and we've got some real expertise. I'm simply doing a welcome and an introduction of the speakers. The first speaker is Gehan Gunasekara. Welcome, Gehan. Gehan, of course, is from the University of Auckland, Associate Professor and Deputy Head at the Department of Commercial Law. So Gehan has published many articles. Some of you who studied at the University of Auckland and have been in the Owen Glen Centre may have had Gehan as a lecturer. So he's really going to provide that perspective. But most relevantly, Gehan, you now are the chair of the Privacy Foundation of New Zealand. So you have been very much involved in the legislative framework. We often see you in the commercial media commentating, providing independent and expert advice. On Gehan's left, welcome Leah Parker. She is the Data Protection and Chief Privacy Officer of Air New Zealand. So a big company which has been in the news, Leah, and continues to be. I don't think there would be an industry where people have more connections from about privacy right at the very first stage. I think we all remember a decade or so ago, oh, could you tell me whether my sister is on the flight and what time? And there were little signs that check in. Well, it's a lot more sophisticated now, and you really are going to provide us with that background for a company that all New Zealanders like and cherish. Our third panel member is Laura Chapman on my right, a senior associate who joined the firm from Singapore relatively recently and has worked in London, Singapore and Hong Kong. So we'll provide all of that expertise as well. And the final person I wish to introduce is another one of our senior associates, Scott Worthy, who, for those of you who are clients or fellow practitioners we work closely with, is well known, a former judge's clerk at the Employment Court, a panellist last week at the New Zealand Law Society Employment Law Conference, and he's been involved in many privacy complaints, including dealing with the Office of the Privacy Commissioner. So with that, too long an introduction, I suspect. I'll ask Scott to take over and give us a summary of the key changes before we hear from the experts. Scott.
Hello everyone, and great, thank you very much, Peter. Just a couple of technical points before we continue on. If you're watching remotely, then please select speaker view. That'll be the best picture. And if you do have any audio or technical issues while you're watching, just use the Q&A function to send us a message, and the technical wizards at the back will fix it immediately. We promise. The Privacy Act has had a long gestation. It's been in Parliament for some time, and it's finally got passed, and it will come into effect on 1 December this year. There are 4 key changes that's worth keeping in mind as we have this discussion today. and we'll be going over these points in more detail, but just as a quick briefing, the first point I'd make is that there are now notifiable privacy breaches. So that's where something goes wrong, there's an inadvertent, accidental disclosure information, something happens, and there is a requirement to report where it's reasonable to believe that breach would cause serious harm or may cause serious harm. And in that case, the person who made the breach has to notify the people involved, but also the Privacy Commissioner. And it's an offence to not report a privacy breach in that circumstance. So that will be important to work out, and we'll have a discussion about that in a moment. The second point is a new information privacy principle. It's number 12. And it's about sending information overseas. And basically that says that a New Zealand agency, entity, person shouldn't send information it has overseas unless the person explicitly consents to that information going overseas, or the foreign jurisdiction has a comparable scheme to the Privacy Act to keep that information safe, or the person you're sending the information to agrees to keep the information safe in a way like they would if they were in New Zealand and the Privacy Act applied to them. Number 3 is increased powers of compliance of the Privacy Commissioner. The Office of the Privacy Commissioner can now make a compliance order telling you to do something about personal information. And if a person makes an access request and complains about that to the Privacy Commissioner can order the disclosure of that information to the person. And the last thing, the last point, number 4, is that there are a couple of new offences that's important to keep in mind. That's now an offence to give false information to the Privacy Commissioner. And it's now an offence to destroy any documents that might be the subject of an information request. So things can't vanish anymore if they had in the past. So we hope not. None of you would, of course, do anything like that. With that background in mind and those brief run through, I want to involve our experts here because they're the people that you want to listen to today. And we'll start with Gehan maybe, and we'll come back to the serious harm issue. And if you're an organisation and something bad happens, how do you decide if that's bad enough to be serious harm?
Well, I think that's going to be very difficult for most agencies. I think all of us who are lawyers will understand that one of the ways lawyers assess serious harm is to think about negligence, which we're not very good at in New Zealand, but Americans obviously are very litigious, but in New Zealand we don't do negligence lawsuits very much. But negligence has established standards for establishing, when can you foresee who is likely to be hurt by this? Who is my neighbor? I mean, that's essentially what negligence law is about. So most agencies will know that they have their customers, their employees, those are the people that might be the most directly affected. But they can't be expected to foresee that down the track, there might be somebody else, way down. Those of you who are lawyers will remember there's a famous case, I think Palsgraf, Long Island Railway. So in that case, a guard was helping a passenger to get on board the train. The parcel fell down, it contained fireworks, it exploded. But the passenger wasn't hurt. The shockwave caused a scale at the other end of the platform to topple onto the plaintiff who was injured. And so she sued. And the question was whether the railway was responsible. And the judge said no, because you can foresee harm to the person you're helping, but you can't foresee that further down the track. So the reason I mentioned that case is I think that is very analogous to trying to decide what is proximate, who is going to be affected downstream. And I think there had to be a reasonable assessment made because you can't imagine every situation that could happen. But I think if it's the data is obviously sensitive in nature, it's got financial implications for the person, it could have sensitive family information, it could result in emotional harm to that person, then I think you have a duty to notify. But other types of data, I think the danger is, of course, there will be over notification. The commissioner will be notified, and there will be people who eventually get notification fatigue. So I think that is a concern.
But is it the safest thing to do if you're not sure to notify them?
I think there's going to be a lot of pressure on the commissioner to give advice, and I think people will go to the commissioner and say, "Look, this has happened. Should I be notifying?" And the difficulty here is, Scott, that I've talked about this before, and I gave a talk to a group of information security specialists, and a while ago, while the bill was in its gestation. And I said to them at that point, well, organizations need to understand their customers better or their clients and know what their situation is. But they push back. They push back and say that goes against the very heart of a data privacy law, which is to collect the minimum information we need. And if agencies need to find out more things about, are you especially vulnerable? Is your address something that you wouldn't want anyone to find out? Holding that information is itself dangerous. So it's a no-win situation for many agencies, I think.
Well, that's not good news, is it? But
sorry, I didn't want to
you
put it
mentioned
down.
the Office of the Privacy Commissioner, and you said, well, maybe you could ask them. But what happens if they have a different view of this than you as the employer or the agency have about what serious harm is?
I think that the other point to note is that serious harm, it must be a higher threshold than the existing harm thresholds in the Act, where people can complain or sue. So at the moment, we have a complaint-based system where you can complain to the commissioner, you can go all the way to the Human Rights Review Tribunal. And there have been lots of cases, obviously, over the years. Now, those cases have established certain standards that you can't just complain for trivial things. There's got to be some, either actual financial harm to the person or a loss of a benefit. They've lost their job as a result. And then, of course, the catch-all, of course, is injury to feelings, but it's significant humiliation, significant injury to feelings. You can't just complain, got a very, very sensitive nature. So, but this has to be of an order above that. So I think that gives some protection to agencies to think the types of harm must be something that is even more serious than perhaps suffering injury to feelings or something like that. It must be something more serious. So there is some guidance in the Act. The Act talks about emotional harm. It talks about harassment, sensitivity of the type of information. But so that gives you some guidance, I think.
Does it matter how many people get the information? So if only one person gets the information, is that relevant versus 1,000
Well,
people?
There's a list of the criteria, and in section 113, sensitivity, you need to consider who might have obtained the information, the types of likely harms, the security measures you had. If the information is already encrypted, how likely is it someone could unencrypt that? The steps that you've taken to retrieve it. So if it went to one person and that person has already deleted it, then I think you don't need to notify. You can be fairly sure that you've done everything you need to do. So again, it's like negligence. You need to take reasonable steps. You don't need to take every imaginable step. I think the law has to strike a balance somewhere, and I'm guessing that the commissioner will take that kind of view, because otherwise it would make life intolerable for all of us, I think.
So,
including the commissioner.
So maybe if we turn to you, Leah, and say, okay, so you've got a problem in New Zealand. How are you dealing with serious harm? What it means?
So full disclosure, not a lawyer, very, very misplaced accountant, risk management professional who fell into privacy, as kind of most of us end up doing. So I think about this in terms of like risk management, and I'm a bit of a geek for a good heat map. So much to the demise of some of my legal counterparts. So that's how I've kind of framed this up to go, okay, let's look at the data that's actually, potentially been compromised or compromised. And if you look at that kind of in a silo, how bad could it be, right? Including a whole bunch of people's email on a mundane email and accidentally forgetting to BCC, maybe some inconvenience. I'm possibly a bit annoyed, but it's not going to go further than that. Versus, information about someone's mental health or physical health, which is inherently more sensitive. And then once you do that analysis, you kind of go, well, based on the measures we've got in place, based on who we know it went to, is this publicly available data, or is this actually something that, only Air New Zealand knows about the individual? Using that heat map to kind of go, does it sit in the red, does it sit in the orange, and does it sit in the green? And based on that assumption, I think you can start to have more detailed discussions with the people who are in your response team, because I would encourage you not to have these discussions in a silo. Often, it's managers, it's business relationship people, it's your legal team, it's your PR team, who've got some of that context that you might not have. And I think having that is also really, really important. I often get, particularly from my digital team, to say, just tell me what data is sensitive and I'll go the extra mile to protect it, right? But it's not a field, address, as you mentioned, I think is a really, really good one. It's a huge percentage of New Zealanders that if that information is exposed, they feel physically unsafe, right? You've got people who are in, safety sensitive roles, victims of domestic abuse. You've got to consider that if it's a big enough population, you've actually captured some people that fall into that bucket and do that analysis. It's not easy to do some of this analysis, but you do have to think about it. And then the other thing that we're doing in a bit more detail than we have done in the past is really making sure we document how we make these decisions. So if we are challenged, because obviously the fine comes if you've not reported, so that you're able to go, well, actually, John, I didn't report this because, XYZ, it didn't meet this criteria. I was really confident at the time it wasn't going to result in any harm. And you can prepare that kind of that good analysis that you've done in the heat of the moment. I also think not being too quick to judge and making sure you have all the facts. I think often, in breach scenarios, you've got people who feel like they're really under the pump and in the pressure cooker, and stepping back and making sure you've got all the facts, which sometimes might involve actually getting some external IT forensic people in, which does take time, which makes people uncomfortable because you want to be able to make a decision on these things. But yeah, taking that time to really make sure you've got all the facts, because worst scenario is you actually go out to someone and later you have to say, oh, sorry, that wasn't you. And you've actually created created harm by your notification, which isn't ideal at all. So that would be probably what we're doing, how we're thinking about it.
I think that's something that the OPC, the Office of the Privacy Commission, picks up, don't they? Because they say it's not always going to be appropriate to notify people, because in some circumstances notifying them will cause more harm than not notifying. So it's not even just that.
Yeah.
That point is kind of further down the track as well.
Yeah, and also thinking about your ethical responsibility. So if there's something that person whose data has been breached can do to further protect themselves, whether it's as simple as kind of going in and changing a password on an online account, or maybe being slightly more diligent in how they manage their online life, you probably should be thinking about telling that person, because actually they're looking at further harm down the track. And even though that might open you up to a bit of risk, my experience definitely is those messages are helpful to people, and that actually does build trust with employees and with customers.
But do you think there's going to be a risk of over-reporting? Not in your organisation, because you're going to take a very balanced approach. But do you think that's going to happen?
I absolutely think that could happen. I think as I said, it's having been in some of those situations, you are in a bit of a pressure cooker, and we as organizations, as people, want to do the right thing, and sometimes that means we do things a little bit too quickly, or take more risk adverse approaches.
There are grounds to not disclose. And it says you have to disclose as soon as it's reasonably practicable. But apart from that, there are exceptions that are listed in the Act, and one of them is where there's a possible breach, a criminal act. You can go to the police first before you do anything else. And I think it's wide enough. Their exceptions are wide enough to cover, even if you need to do a forensic inquiry within your own organization. Let's say you've got a leaker or some disgruntled employee who you want to basically catch that person. If you go public, you're going to give up. You give up your hand, and they'll be tipped off, right? So you might need to. And there may be situations where you are entitled to do that. I think it depends on how serious the threat is, and if you've got a reasonable belief that it is that person who's doing it, then you can withhold until you can catch them in the act.
So that's a tricky and interesting issue, and maybe there might be some guidance from the Privacy Commission, and more guidance coming about that issue to help us all out, which would be really helpful.
Their website currently actually has a online evaluation
Tool.
and I appreciate that, you know, that's subjective because you might deem it to be unlikely when they say you should have deemed it to be likely that it could cause problems. So I suppose you could run, I as a manager would think to run a number of scenarios and see where's the threshold and then deem, okay, and you'd certainly want to, I imagine, keep that record as to what you've done and why you've done it.
Documenting why you decided something's low versus high, because the tool actually is that binary. And these incidents usually aren't. They're usually a bit curly, so you do have to take a position to kind of get there. And I think documenting and really thinking about that position is going to be really important going forward.
There's probably the tricky ones that the tool won't help you with, the really obvious ones
Yeah.
that you shouldn't or should report. You'll probably
Yeah.
know yourself.
Yeah.
It's the tricky ones that you probably want some help with, and maybe it will fall down there. One other topic, perhaps we can move on from serious harm, is back to you, Gehan, is about if an employer has personal information and is transferring it to third parties, what's the potential liability if something goes wrong or the Privacy Act isn't complied with?
Yeah, that is a very interesting issue. I made some notes on this because it's quite a the key point is, I think this engages two of the privacy principles, Principle 11 and the new Principle 12, of course, the cross-border one. But the key is, why are you transferring the data? For what purpose? I think that has to be the predominant criteria. If the transferor remains liable, if you're transferring the information for somebody for your own purposes, not for their purposes. So in other words, if you're using a cloud provider, for example, just for storage or something like that, you are still responsible for that. You can transfer the data, but the person who's transferring it remains liable if anything goes wrong with that data. But if you're going to transfer it for the transferee's own purposes as well, then that engages Principle 11 of the Act, as well as if it's an overseas transfer, it then engages the new Principle 12. Unless one of the exceptions apply. So there's health and safety exceptions, law enforcement, obviously. But if it's anything other than that, and it's an overseas transfer, I can give you a couple of, there's some interesting examples here. So here's an example. Let's say you have a corporate group and the corporate group has many subsidiaries. And there's a centralized IT or HR service provided by the parent company. Okay, now in that situation, each subsidiary is the principal, or in the European language, it's the data controller. Each of the subsidiaries in that case is the controller. They're deciding what that centralized service is going to do. The parent company that's providing the centralized IT or HR service is simply acting as the processor or the agent of the subsidiaries. But if the parent company decides to do its own analytics on what the subsidiaries are doing, let's say it wants to study efficiencies across all its subsidiary groups to see which of them is performing better, employee retention, for example, things like that. If it wants to do its own kind of analysis on that data, that makes the parent company also then a principal, and it means that then they also are doing business in New Zealand under the new test, and they would need to comply with our Privacy Act. So it's things like that that I think officials need to think about. What are the purposes? Why are you transferring that data? For your own purposes, you remain responsible. Whether it's for someone else's purposes as well, they then become an agency on their own account. I think that's a correct kind of analysis if you want to. But there's very little case law on this in New Zealand. So, and the case law that is there is very mixed. So I think, we'll need guidance from the commissioner, but probably ultimately until it's litigated, we won't know how those issues are going to be resolved.
That problem comes up a lot because there's a lot of companies that are, of course, their own entities, but transfer information to related companies. And that can cause problems, can't it?
And we don't have a related company exception in our law, unlike Australia. So the Australian Privacy Act has within an organization, even an intra-organizational transfer can still be caught by the Privacy Act. Because if you're transferring it to a different branch of your organization, but for a different purpose, to the purpose that you're using the information for, that is regarded as a new purpose of the transfer. You may need to redact some of the information. Right. I mean, that's the other thing you could consider doing.
Because the person who gathered the information is disclosing it to that other body, even though it's a related company, and might even own the employer.
Yeah.
Yeah.
And so it doesn't matter that it's all the same company,
Yeah.
if you're transferring the data. So there have been cases in the employment context, for example, there was a bullying allegation, and the other branch of the company needed to know so that they could tell the person who was being accused of bullying what it was that the person had was accusing them of. For natural justice, they needed to do that. But when they made the disclosure, they also disclosed other details about their personal situation and how it had affected them and so on, which really wasn't necessary. And so that then became technically a breach of the act, because there was new information that was disclosed. What they should have done was to have redacted it and just given the essentials of what happened, and this is what,
And maybe, Leah, do you have some insight there in terms of redaction, and also what is Air New Zealand doing in terms of exporting data and controlling that, including internationally, which obviously is a big issue for you?
Yeah, I mean, an airline absolutely cannot exist without the sharing of data, and particularly without sharing in that kind of controller to controller, right? You often go on an international trip, and you might not fly on Air New Zealand, you might fly on 2 or 3 airlines, and actually you might also book your hotel, and you might book your taxi, and you might book some experience, and all of a sudden there's a lot of data that Air New Zealand controls. But as soon as you engage with that third party, we'll share that information with you, with your permission, obviously, by you engaging in that service. And then that organization also becomes a controller of your data. So we actually went through a lot of this pain back in 2017 when we were preparing for the GDPR. That has a reasonably similar concept, maybe a slightly better articulated concept, around explaining what a controller is and what a processor is, because I think the way it's worded currently, you can tie yourself up in knots a little bit trying to understand what the relationship is. So we did a massive inventory of all of our contracts that involved kind of the sharing of data, and did some analysis, are they a processor on our behalf, are they a controller, making sure we had the right contractual terms within those contracts. And then going forward, we have to introduce additional governance around that. So now all contracts that involve, and all relationships that involve the transfer of personal information actually need to go through me and my team, as well as our legal team, to make sure that these discussions are held, because often the people who are procuring these services, they might not quite ask the right questions. And it's only actually once you start turning the lights on to some of these systems and these services that you go, well, actually, we're giving a whole bunch of employee names, and we thought this was going to be, an anonymized service that, would be great to offer for our employees to have. So making sure those questions are asked up front, so that, you're making sure you've got the right terms in your contract and you're asking the right questions.
And that comes back to, in part, the issue of consent.
Yeah.
And making sure that people consent to the disclosure information up front. Is that still okay?
We tend not to rely on consent because it's incredibly difficult, right? Especially in the concept of GDPR, because consent needs to be freely given. You need to be able to take it away at any time.
people can withdraw the consent.
Which is very difficult for any organization of any size to be able to manage. So you kind of want to keep that quite narrow. But if you're entering into you want to fly on Air Canada, I think you can reasonably expect that Air New Zealand would then transfer your information to Air Canada, and actually you would want Air Canada to do some stuff with your information so that you get the seat you want, you get the meal you want, and you actually end up where you want to go. So thinking about some of those things.
So if I'm thinking about it and you ask me for information and I say that's fine, you can use that information, why isn't that okay? What problems could arise then? If I've said that's fine, go ahead, use whatever you want.
Yeah, I think I don't think we'd quite go down that path.
Right.
To Gehan's point, I think minimization is a really important concept that you've got to think around about whenever you're sharing data with anyone, whether that's a partner, a third party, even between your colleagues, thinking about what's the minimum amount of data you can share so that that person can get the service or goods that they've requested.
Yes, definitely a minimum amount you can collect.
Yes.
As soon as you have that data, you're responsible for it in a way. And I think one of the issues that we came across a lot in relation to consent is people are consenting to the way they understand you will use the data. They're not consenting to how you will necessarily use the data, because you can't always give them that information up front. And to your point earlier, and actually Gehan's point too, one of the issues that we've found in establishing something like whistleblowing hotlines, for example. So something in regulated environments now, most companies of any size will have some kind of concern hotline or a call or an email to a centralized system that says, I'm concerned about fraud, or I'm concerned that health and safety regulations aren't being met, or I'm concerned this happens. Now, doing that almost necessarily always involves disclosing some sort of personal data, not about the person who's making the report, but about somebody else. And because some of these have international effect, it also means you're often disclosing the information internationally immediately. Now, you can't get the consent of the person who you're telling on, essentially. So I'm not going to come up to Leah and say, Leah, I'm concerned you've perpetrated a fraud, so I'm going to go and make a report about it. Do you consent to me doing that? And you can't upfront adequately get someone to have that consent. You can say we operate a hotline, and you can participate in that hotline. You consent to your details being given as part of that hotline, because immediately, especially new employees, you're saying to a new employee, we might investigate you, which is not a good look. So it's very difficult for those kind of processes to actually rely on any kind of consent. And then consent means different things in different places as well.
Okay, so consent might not be enough.
No, and I think Leah's point about it needs to be informed and specific. You can't have a general consent for everything.
No, you can't just consent to everything forever.
No, not under GDPR. Probably not under that.
Yeah, it's not really fair, is it? So it's consent is an option, but I wouldn't rely on that as my first option. There might be some use cases where it's a small audience and it doesn't make sense, but I struggle to think of an example where you'd want to rely on that.
And the other major difference with GDPR is, I know we're not supposed to be talking specifically about GDPR today, but GDPR, whereas in our privacy principles, if you're familiar with our privacy principles, most of them have consent or authorization built in as an exception. So you can not comply if the individual has authorized you to not comply. But with GDPR, even if somebody gives their consent, you cannot contract out of. Essentially, you still have to keep the basic rights that person has for proportionate processing, limited purpose, all of those things you can't consent out of under GDPR.
And just to clarify for anyone who's not sure, but GDPR are the General Data Protection Regulations in Europe, and they are often held up as some of the most stringent data protection regime in force. And it has what we call extraterritorial effects, so it applies outside of Europe to the extent you're processing data from residents of Europe, essentially. It's a lot more complicated than that, but to give an overview as to why we talk about that, because even for Air New Zealand, again, if you have someone from Europe who's flying on your services, GDPR will apply. And a lot of the changes around data protection that have happened in the last few years were either in anticipation of these regulations coming into force in Europe, or they were as a reaction to them, because, again, similar to the way in which New Zealand has enacted its own rules around exporting personal information outside of New Zealand, GDPR has, as I say, similar but very strict obligations, so that if you are exporting information to a country that, like New Zealand, who didn't have adequate, according to GDPR, adequate data protection, then you had a lot more steps to kind of put in place, and that's sort of driving that, which is why we mention it in the context of the New Zealand regulations.
So that leads us on to the sort of international experience, because in a lot of ways the Privacy Act 2020 is following on from a whole series of the kind of privacy revolution that's happened overseas, and we were one of the last people to catch up. And maybe we haven't caught up. Maybe some people think we haven't gone far enough. But when you were working overseas, what were some of the key issues that you ran into privacy-wise that probably are going to replicate themselves here?
So I think, as I say, the kind of whistleblowing issue is one of them, but because workforces are becoming more automated, we are speaking now to a number of people who aren't in the room with us, some of whom are overseas. And so you are automatically already sending personal data to outside New Zealand in some respects. and to other organisations without even necessarily consciously making that decision. And there's a lot of law overseas that's gone into thinking about, those processes. In employment, where we see there being big touch points hasn't changed dramatically under the new legislation, but what it has done is it's kind of enhanced awareness of rights. It's enhanced the kind of number of complaints that we see, and it's enhanced the way in which we have to react to those in an employment context. And to give you some examples, another one as well as whistleblowing is employment investigations. It's a matter of course, every business has them. When you're going through an employment investigation, one of the things you might have to do is a forensic audit of your employees' computer, essentially. So their emails, looking at what they've been doing, who they've been communicating with, etc. In New Zealand, it's generally relatively straightforward, not as a complete rule, but generally we say if it's the employer's systems, then the employer owns that information and has a right to look at that, even more when it has policies and procedures in place to say we can look at those systems. But one of the issues is you have an increasing meld between the personal and private lives. And so people conduct personal work on their work email sometimes, and they might have communications otherwise. Some employers, that's fine. To some extent, it's inevitable in some places because people have longer hours, they're doing work. Now, where that became an issue, for example, is if you were doing a forensic audit of someone's computer, there is a number of people that might see the emails in relation to that, and a first level review might pick up a whole lot of the information that isn't necessarily relevant. And to give you a specific example, we had an investigation where, again, there was an alleged misappropriation of funds in relation to someone, so they're investigating this. As part of that investigation, it came out that person was HIV positive because of some medical information that had been shared via email and some kind of updated medicine. Now, the issue in that case was that at first level review, there were a good 8 to 10 people that probably saw that information that disclosed that person was HIV positive that they otherwise hadn't disclosed more widely. Now, you can see in those circumstances, we're talking about some of the concepts we were saying earlier, it's sensitive data. You can see that someone might be upset by the fact that people or colleagues that they're close to have found out this information about them through a way that hasn't been consented, essentially, because their policies and procedures didn't disclose that they would be auditing this for the purpose of these kinds of investigations. So there was a real issue in relation to that, and you can see that coming up more and more. So that's on the investigation side. Even on the general kind of collection of data, if you think about the sheer volume of data you collect from your employees about even their kind of medical health, if they've been away from work, they give you a doctor's certificate, and they sometimes tell you what's been wrong with them, what's happening. There's a lot of sensitive data. You've got their bank account details, you've got their career details, there's all sorts of information. Now, as we're saying, there is a real specific purpose for which you are collecting that data, and you need to minimize that to the extent possible. Now, one of the things the changes have done is we're all talking about this, and what we noticed in Asia when new regimes came in, everyone was talking about it, employees became very aware of it, they become very aware of their rights, and then they do happen to make complaints on these issues quite easily. And one of the things I don't think we are good at doing yet in New Zealand is putting in things like our employment agreements a data privacy clause to say this is how we will generally use your data. And again, it doesn't get around your consent issue because you can't consent to everything, but what it does is inform your employees at the very first step what sorts of information you will have access to and what you'll be using it for. And it also gives them an idea of where it will be transferred to and where that will be going. So as I say, there's those kind of touch points in employment that we see it more often.
Yeah, I mean, I think that's a really good point. So we've got an external facing privacy policy that's on our website and everyone can access it, but we also have an internal facing employee privacy policy that says when you apply for a job, this is what we collect, this is how we use it, this is how long we keep it for. When you engage with us in an engagement survey, this is how this works, the EAP program, and all of these various different touch points as you kind of go around that journey in your career. And it's at a high level, it's not in detail, and it is a bit of effort to keep it up to date. Yeah. So tread lightly and resource appropriately, but it is actually quite a helpful document. And it actually starts to govern some of the things that people in the organization do, because we go, you checked? Is that me? Have you told employees you're doing that?
Mm-hmm.
How are you going to tell employees you're doing that? And so it makes some of those conversations a little bit easier.
And your experience overseas, so you mentioned some of the things employers have done.
Mm.
What other steps can employers do practically or as part of their policies and how they approach things that makes a difference?
Yeah, so I think you can, a lot of this, and despite us saying consent won't work, a lot of this can be front loaded. Not all of it, but a lot of it can be if you spend some time to think about, as I say, what data you'll be collecting, the purpose for which you'll be collecting it. So what will you actually be using it for? And then how will you be treating it? So when you are paying people, does that go to a third party? Often it does. When you're doing performance assessments, do you have external advisors come in and help do training? Will you be sending data, for example? As lawyers, we talk a lot and our details are sent out to a lot of people when we're doing seminars, etc. And how do you make sure people are aware of that? And I wouldn't, this sounds like obvious things, like I should be aware that my name and my image is going out to a lot of people, but again, it's often not. And I think a lot of the time that is not the common sense that you think might be common, that is not so common. So coming back to front loading these things, exactly as Leah says, have policies in place that are internally facing as well, that talk about how you are going to treat your employees' data. I think put a clause in your employment agreement if you can, so it refers back to your policy. So there's a place where they can say, this is where I find the policy and can look at it to the extent you update it. When we're talking about investigations, one of the things we used to often do is looking at impact assessments. So we would look at making sure that where there was going to be a first level review, we've thought about who was looking at that, how many people are looking at that, and to what extent have they agreed to keep that data confidential, and how will they be storing it. Once that first level review is completed, where is that data going? Is there a less invasive way of doing this? Can we do this in a way that has less of an effect on that person's privacy? And if the answer is no, then exactly as Leah said as well, document that the answer is no. And actually some of these documents are barely, once you've put it together and you've gone through that process once, you have to adapt them, but they don't take long to put together. And there's an extra step that if you do get a complaint and you do have to notify the commissioner that you have this complaint, they come back to you and you say, yes, we've thought about all of this in advance, and here are the steps and processes and protocols we took and we put in place before we did it. So as I say, it takes a bit of time, as Leah knows, to get all this in place, but once you do, you're in a much better position as far as when you have an issue. And I say when, not if, just because it's the nature of the things we're talking about here. It is a when.
A lot of employees might have a policy at the moment that says if you're doing work on our system or our laptop or whatever, we can just look whenever we want. Do you think that's going to be the way of the future? Is that impacted by the Privacy Act? And do you think that's a good idea? It's something that's going to hold up in the future? Or we should be careful about that idea?
I think you're actually seeing more of that type of behavior, with the impacts of kind of COVID-19. Employers are nervous about people, working remotely and what are you doing? And you're seeing kind of cases pop up here and there, particularly in America, around, keystroke monitoring and cameras being turned on. And some of these things they're very creepy, right? But, you are kind of seeing more of that. But I think, to Laura's point, letting employees know that that's what you're doing and that's how you're treating email, so that employee can make a decision around what they're storing in their email. And so, you're informed and you can decide whether or not you think that's an appropriate risk for you to take. I think it will be interesting to see what happens. You've definitely seen in the EU it swing the other way around, it being very clear that, people are entitled to privacy within their workplace. But yeah, it'll be one to watch for sure.
I think a very interesting question I got asked in Hong Kong was, and this is for everyone at home thinking about this, I don't know how many of you have iPhones. Now, what most people don't think about is if I said to you, your employer has asked you to wear a device that it can track you at all times of the day. So it can, at any moment, look up and find out that Scott is at his home, Laura is she is at a shop downtown, Gehan's here. Not many people, I would hazard a guess, would think that's reasonable that your employer can do that. But if you think about your find your phone function on your iPhone, actually that has the potential to operate in exactly that way. And we had a question from an employer once saying, can we use this in an emergency? And we said, what sort of emergency are we talking about here? And actually what it turned out is they were trying to figure out, ultimately, could they use that as a tracking device that if they didn't know where one of their staff was who was on the road and doing different things, could they look up and find out where they were? And the answer under the particular regime was no, you can't. But it just shows you how technology is changing, and that's not new technology. That's been around for a long time, and why those sorts of issues I think will become more important.
But if there was a serious threat to that person's health or something like that, then the answer would be yes.
Yeah, exactly. If there was exemptions, or if you thought, for example,
they've been exposed to COVID or something, and they were traveling around exposing
or there's significant mental health issues, and you're worried about that person because, and again, I had that experience where we've had to find someone quickly because they're very worried about their state of mind. And in those circumstances, you're absolutely right. The answer might be yes. As a matter of course, no. So there are different answers to those questions.
So maybe, Leah, we could ask you about where are the hotspots, or where should employees be worried? Where are the highest levels of risk in your view, so that maybe employers can, if they don't have time to do everything, maybe they can start there.
Yeah. What probably makes me the most nervous, and particularly in kind of the HR world, it's your unstructured data, right? It's your spreadsheets that, are lists of health and safety accidents and payroll reviews and performance assessments, all of this stuff that sits out of your core systems, or you extract it out of your core systems, because I've experienced these HR systems never seem to do 100% of the things you want them to do. So you need to pull the data out and do all these crazy, wild things. And inevitably, you pull the spreadsheet out, you do what you need to do, you share it with who you want to share, you dump it in a shared drive, and you leave it there to rot. Someone finds it or something happens to it, and all of a sudden you find yourself in it. And at the risk of telling everyone how to suck eggs, I did record my top 4 tips, more from a data management point of view, because again, these are where these types of things start to go wrong. And my top tip is to Marie Kondo your documents regularly. We all carry way too much weight in our shared folders, in our OneDrives, in our emails, and in the 1,000,001 places the lovely digital teams have given us to store data. Isn't it great? And inevitably, you don't need those anymore, right? They're point in time, and we're not going back. We're not ensuring the accuracy of those. We're not regularly reviewing to see whether or not access is appropriate. At least you're just wearing risk for no point. So yes, set some time aside in your diary, a couple hours, half a day, treat yourself to a coffee or a beer after, whatever your preference is. We've had a few where we've done this actually as a team sport, where the entire team has gone through the pain of kind of sifting through old emails and files and just deleting securely what they don't need. Same goes for those lovely paper-based folders that you've got sitting there. Pop those documents within a secure shredder. Be an IT security professional, which is probably not something you expected me to tell you, but security, just like privacy, it's a real team sport. So again, we're now all kind of IT people, right? We spin up team sites at the flick of a hat, and we share and we collaborate, and it's very wonderful. But we never again go back and say, are all these people still in that project? Are all these people, is it still appropriate for all of these people to have access to this document? And, Air New Zealand in particular, we've really changed from what we were in February. So this has been really, really important for us to keep doing that. Your shared folders as well, that's another thing. Sometimes we like to think IT is doing that for us. And in some companies, that's the case. But in a lot of companies, actually, if that's your department, you own that risk. And you need to go through and say, hey, IT team, tell me who has access. Can you remove these 6 people? Think before you share, I think is a really good one. So whether that's internally or externally, we all need to be going, is that person really authorized to see that data? And then looking at what you're sharing and going, is it actually all those fields that is relevant? Or actually, Am I only required to share name or phone number and not, talent rating or personal email address, and kind of paring it back whenever you can. And then share safe. Every organization has their own kind of rules around what's safe. Are you allowed to use Dropbox? Aren't you? Some of these things have been turned off automatically, but for some of us, it's down to understanding what is the approved mechanisms to share those documents. If you're going to email something, please put a password on it. It can never go wrong, right? It's a little bit of a pain in the butt, but you're not going to find yourself in trouble at the back end if you've made a boo-boo, as we all kind of do from time to time. So those are kind of my top tips in terms of managing that unstructured data risk, which does kind of unfold every so often, unfortunately.
That's really helpful. We should all anybody want to comment on any of those points?
I would just add that those are all things that every organization should inculcate. They should have within the internal facing policy, not what you share with everyone else. And then having the policy is not enough. You need to actually make people aware of it. So it's a type of governance. You need to have an internal security governance procedure, and maybe spend one day a year or half a day a year where you run a training workshop for your staff and you go through it and you say, these are the things you need to be aware of. You could even do it, now with technology, you could set it up so they do a seminar themselves online. They go through the module, they go through the documents, tick the boxes, and then you'll be able to prove if there's an investigation in the Privacy Commission that says, have you trained your staff? Yep, 80% of our staff have actually gone through and clicked on the module and done the work.
And I think the only two things I would kind of re-emphasize in a way, because I think we've covered them, but one is you need to have a Leah, or obviously Leah's busy, but you need to have someone in your organization that understands privacy issues and is responsible for actually making sure those processes are in place. And I think that's critical, because otherwise, if you have a number of different people, looking at a number of different things, sometimes things can fall through the cracks, exactly as Leah says. And the second part was something Leah mentioned earlier too, but just have that crisis process in place. Think about what you will do if you have a data breach of some kind, and what steps will you make, because often, these things can be, especially if it's a bigger breach, it can be slightly crazy, and there's a lot of people working on a lot of different things, and you need to know that you've got a central kind of position, or at least a process or protocol to actually deal with them, to remind yourself of how that works, and think about it in advance, because exactly as you said, it's too late.
It's always Friday night, right before a long weekend. And if you can put your brain on autopilot and work through those processes, you'll be far more ahead.
Yeah.
And every every agency has to have a privacy officer. It's a requirement, and I think that's one of the things the commissioner might actually try and enforce, because under these new enforcement powers. And there's a compliance notice power. And I think the compliance notice power, is going to be more important than the actual breach notification, because every time there's a breach, it's a window into your organization. And that will allow the commissioner to say, oh, maybe they're not doing things properly. I'm going to serve a compliance notice. And we did a survey, we did a project a couple of years ago and analyzed 4 countries, so Australia. We only looked at New Zealand, because although New Zealand didn't have compliance notification, but we looked at Hong Kong and the UK. And we looked at all the breaches that had happened. And it turned out that more than half the data breaches were due to the kinds of things Leah's talking about. Okay, so people hanging on to information longer than they needed, retaining access by people when it was no longer justified, if people had left your agency and so on. So more than half the breaches were linked to retaining data when you didn't actually need. So I would say as part of your governance framework, you should look at having a retention schedule, saying, which categories of data do we purge, do we get rid of after a while? And I think now you need to have that information so that you can produce it to the Privacy Commission. They come after you and say, and then you can say, look, we've got this. This is our retention schedule, and you'll be one step ahead, I think, if you did that.
And I think the Privacy Commissioner has made clear that he's going to use some of these powers, and in fact is itching to do so. And so unlucky first privacy breach employer will probably get a little bit of a visit And as Gehan said, if there is a privacy breach, it's an opportunity for the Privacy Commissioner to rummage around in your organisation and check and see if you're actually complying, and if not, to push you on the right path. So better to do it in advance.
Absolutely, yeah.
Yeah.
Be proactive rather than waiting for that to happen.
Absolutely. We have just time for a couple of questions. One of the questions is just about back to this issue of New Zealand subsidiaries and sending information overseas for reporting purposes, financial reporting purposes. And if you're going overseas in order to, in essence, report to head office, that head office is a different company, are all the rules about foreign transfer information going to apply?
Well, that comes back to the point I made about for what purpose. If it's for your own company's purposes, then, but if head office is going to be using it for their own purposes, then it is regarded as a transfer. And then it may be that you have, that country itself is regarded as a country that has, is regarded as a prescribed country. We don't know what countries are going to be on that list. It's going to be released sometime later next year, I think early next year. But the other thing, of course, is you might have a contract with that company that guarantees that they will respect New Zealand privacy law. So there are mechanisms that can be used to safeguard it. So I don't think people need to be afraid of that. But they just need to go through a tick box to say which of these, can we say that it's covered by that?
There are some, the Office of the Privacy Commissioner has released some model clauses in relation to putting those agreements in place, but they've just come out recently, and as a warning, they're quite dense in terms of the language in them to some extent. But the good news is there are some model clauses to help organisations out to be able to have those agreements in place.
And once these agreements are in place, the other thing we found when we looked at these overseas examples of companies is that you have to follow up. In other words, it's not enough to just have a contract with somebody. If the contract says that you'll be regularly auditing to see how they perform, you actually have to do that. And if it says they have to delete information, if you require them to delete it, you need to go back to them and say, have you actually deleted that information? Because if it turns out there's a breach, and quite a few very famous breaches, I mean, the Ashley Madison case is a classic example, Equifax, there are quite a few of these kind of cases. Equifax is a good example where people said they would delete information and they didn't. And then it got hacked and then it got out. So once information comes out, then there'll be questions as to, okay, you promised that you would audit and delete the data. Did you audit and delete the data? And Cambridge Analytica is another one, of course. Facebook was supposed to go back and audit and check what these people were doing, and they didn't.
Is there any question in the room? If not, that's fine. I've got another question here, but let's give you a chance. There's someone here that pop their hand. No, you're all completely satisfied. A final question that we have is about an employer sharing or a company sharing information with its own third-party providers. So if you've got an auditor who comes in to audit your books, or you're using that information and you need to pass it on to an outside agency, but an outside agency that's working for you, is that an issue that to be worried about, Leah?
Again, I think it comes back to Gehan's point around what are they doing. So an auditor is potentially using some of that information for their own purposes, depending on what the nature of that audit is. So considering kind of what are you trying to achieve? Is it an external audit for financial purposes? And in that case, can you not share personal information or limited personal information? I think what was your other use case was around a processor type relationship. Was that like? Or
what about what about if it's just my accountant? I've got an accountant who needs to see all my information and private information of people. Does that present a problem if the accountant's just doing my books?
I don't think so, because he would contract directly to you. And you would be actively providing that information and expecting him to be doing something in relation to that service that you're asking him to do. So I think
and if my accountant loses that information?
It sucks to be you, no.
So
again, that accountant will need to decide what information you actually provided him. Is there a risk of serious harm to you? And if there is, he's got to be telling you and he's got to be telling the
right. But if if I give that information to my accountant, can the Privacy Commissioner come after me, even though I didn't lose it?
In that case, your accountant is a controller of that data, so they or she becomes accountable for the security of that data. I think where it's slightly different is if you kind of go your my HR system provider, you're a processor. I am responsible for letting you know how to behave, how to treat that data. I'm responsible for setting those, contractual terms and conditions and providing you guidance. Now, if that provider had a data breach and all of your data was exposed, you as an organization have the responsibility to do that analysis, to work with that processor, and to follow through your kind of breach management process, which could involve notifying employees and the Privacy Commissioner.
Okay. So thank you, that's really helpful. So that brings our seminar to an end this evening. I want to thank the speakers for their expertise. I'm sure we've all learned a lot from this. I want to thank the audience who are here and online for attending, and I hope you enjoyed the presentation, got something important out of it. I'm sure you did. And thank you for your time this evening. And that's all from us. So have a great evening. Thanks very much. Bye.
Those who are in the room, please help yourself to a drink and some cafes, and we'll be around for a little while if you do have any other questions that you want to answer offline.
Just